Good afternoon, everybody. Thank you for joining us on this Surrey Law Society webinar. I'm sorry that we're a little bit late starting, just a few minor technical hitches, but we should be good now. Just before I hand over to Sue, I just wanted to draw your attention to a few of our forthcoming events at Surrey Law Society. So we've got our Past Presidents Championship Cup on Thursday. That's our annual go-karting competition at Daytona. We've got a in-person course on the 28th of June at TWM Solicitors in Guildford with John Bunker. That's on the use of wills, trusts and variations for IHT planning in the stealth age. And the following day, we've got an online residential conveyancing update with David Keithley. So if any of those sound of interest or you'd like to attend, you can find more information or view our full programme at the Surrey Law Society website, which is on the screen there, or contact the SLS admin office and we will book your place. So housekeeping sessions for today. If you would like to ask a question of Sue during the webinar, you can type this into the Q&A box. You can see there that you can do it anonymously as well if you want to click the checkbox. At the end of the session, Sue will invite questions as well. And you can either do that using the same Q&A facility or you can raise your hand and we'll unmute your microphone. As you probably heard when you joined, the webinar is being recorded. And just before I hand over to Sue, if you could fill out the feedback form when you leave the webinar, it should automatically pop up. It only takes a couple of seconds. That would be really helpful. Right, no further ado, I'm going to pass on to Sue. Thank you, Sue, and see you soon.
Thanks, Alan. Hello, everybody. It's very strange talking into a bit of a void here. First of all, welcome. Secondly, the technical issues were nothing to do with Alan. It was all to do my end, so my apologies for that. Thirdly, I've not done one of these, as I say. I'm used to talking to people about costs, but they were in sort of pre-pandemic days, old days, when I would talk to a room full of people and then I could see reactions and, you know, all the rest of it. So having sort of tried to excuse myself for any rubbish, before I start, I will now start. Right, there we go. Hopefully you can all see this. If not, I'm sure something will appear in the chat. I was asked to do this webinar because what's really important to solicitors on the ground is how you can make your business profitable. Now, I'm a cost lawyer, so I'm coming at this obviously from a predominantly litigation viewpoint. But as you'll see when we work through the slides, litigation and advising, drawing bills, etc., is not the only thing that the cost specialist can do. And strangely, the first and indeed the most important thing, and I appreciate that I'm going to be preaching to the converted on a lot of this, but you absolutely have to get your retainers right in the first place. If there is an error in your retainer, and this applies whether it's solicitor and client, I also, on my own account, not through Elite, usually have one or two litigants in person on the go at any one time, and about half of my litigants in person involve disputing solicitors' bills. And a lot of the issues that I'm talking about at the beginning is to try and avoid the sort of problems and the sort of lines of attack that I'm sometimes able to take on behalf of litigants in person. So as I say, it applies just generally. Obviously, in terms of litigation, if you haven't got a valid retainer, a paying party is always going to attack. Always. They're always going to ask to see your retainer, which they're not entitled to do, it's privileged. But if it gets to an assessment hearing, whether it's a provisional assessment or a detailed assessment, your retainer documents, once queried, have to be filed with the court with a request for assessment. So they can be inspected by the court, and the court will know what to look for. The two biggest cases recently, ones you've probably heard of, Belsner and Karatich, which were heard together by the Court of Appeal. The important phrase in this, and I just realised it's a good thing that I have got a hard copy of this because my little box in the corner cuts off part of it. This is a quote directly from the Court of Appeal in Belsner. In my judgment, it is wholly unsatisfactory for solicitors generally, and these solicitors in particular, routinely to suggest that their clients agree to a cost regime that allows them to charge significantly more than the claim is known in advance to be likely to be worth. Solicitors do not resolve this unsatisfactory state of affairs by allowing a discretionary reduction to their charges after the case is settled. This came into stark relief with one of my litigants in person recently. The value of the dispute that the client had with her neighbours in quantum terms was worth £21,000. So that was what it would cost to rectify the issue. She'd relied on a verbal fee estimate of 20,000 all the way to trial when deciding on placing her instructions. After only 3.5 months in, she'd already been invoiced £15,000, and I know it's only £12,550, but to a privately paying client, it's £15,000. In addition, she paid directly her disbursements and counsel fees. Now, discounts have been given, but this has ended up at a solicitor and client assessment, which is listed in August. Another issue which I've raised, and we'll wait and see what the court says about it, is timescales. Standard terms of business, simply stated, as you're supposed to, and this is on the invoice, if for any reason you object to our invoice, you've got the right to object and apply for an assessment of the invoice under Part 3 of the Solicitors Act. As you probably know, it is absolutely essential that that should be there to render the invoice an interim statute invoice or a statute invoice on which you can sue. Her solicitors had obviously intended all the invoices to be interim statute invoices, but they didn't actually set out effectively what that part of the Solicitors Act stated. And there is this case, 2021 case, as you can see on the screen. And by the way, you will be seeing copies of all these slides, so don't worry about making a note of everything. I consider the defendant's argument runs aground when contemplating the practical difficulty of the client bringing a challenge whilst litigation is continuing. It cites a 2012 case. Under the provisions, they have to challenge an interim bill within a month as of right, and then has to show special circumstances within 12 months. As it said here, as it was quoted in this judgment, that puts him in an impossible position. Either he challenges the solicitor's bill, the very solicitor who's now acting for him continues using that solicitor at the same time, or he has to change solicitor all in the middle of litigation when he's facing another enemy. I'd also add that it also then involves additional costs having been to be paid to the new solicitor. In the Zulfikar Masters case, the court went on to conclude it's for this reason that it needs to be made plain that he's receiving an interim bill. The information given at the outset, i.e. in the retainer, needs to make clear that there are time limits. You need to say this at the beginning. The idea that several months from this case, the engagement letter provided ought to be alive to the fact of the entitlement under the Act if he challenges the bills promptly seems to me to be far-fetched. Consequently, in my view, although solicitors intended the bills to be interim statute bills, they cannot be treated as such, so as to preclude the client from an opportunity to challenge those costs. Consequently, they're akin to request for payments on account, albeit I appreciate entirely that's not the intended nature of the invoices to be rendered. So just as a general point, it doesn't invalidate your retainer, so it's not a strict invalidation of retainer point, but it does give you an issue if you want to sue on bills if your retainer hasn't made it clear what the time limits are for complaining. In other words, you need to extend the simple statement, if for any reason you reject our invoice and you have the right, you need to extend that to include the timescales. So just some general advice on retainers. Obviously make sure that your client is aware of the timescales for rejecting your bills. Give as much detail as possible about your estimated fees, what they cover and what they don't, trigger points at each stage. So in my case, and in fact, just generally in cases your retainer or your client care letter will probably say that you'll account on a regular basis. You might say monthly or whatever. You really need to make sure you do it. Ditto, they might say it's at a quantum point, or it might be a stage in litigation. It has to be absolutely clear what it covers, because otherwise it gives people like me advising litigants in person an absolute end challenge. The estimated disbursements, again, you can never be precise about that, but you need to be as accurate as possible, because if you've estimated that council's fee is going to be 1,500 quid, and in fact council's fee is about 3 grand for what you've estimated 1,500 for, you'll be in trouble, not council, because you're liable for council's fees. And also it would be sensible to say what factors could disrupt that estimate that you've given. There you can throw in pretty much any sort of proviso which then covers you. Do keep the client updated regularly and make sure that you have specific authority before incurring any fees or expenses which are going to exceed your estimate. And I'm afraid we come across this in our normal work time and time again, where that hasn't been done. It's easy to run away with costs. We do it, but despite our best intentions, are supposedly not doing it and advising you not to do it. But it is something always to watch, and that can be done by just tasking a junior member of your team. People don't have secretaries these days, but they generally have a grade D fee and around. Give them specific responsibility for monitoring that. Ditto with budgets, by the way. The hourly rate increases, advise them of the new rates. Otherwise, any work that you do before you're advising the new rates will have to be at the old rates. This is a little funny one. Again, which has come up in this case, which is due to be heard in August. 74(3) of the Solicitors Act. This is potentially an absolute killer. The amount which may be allowed on an assessment of any costs or bill of costs in respect of any item relating to proceedings in the county court shall not, except insofar as the rules of court may otherwise provide, exceed the amount which could have been allowed in respect of that item as between party and party in this proceedings, having regard to the nature of proceedings, blah, 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 blah. Now, obviously, it is only applies to county court matters. There's a get out of jail card that unless they have the client's written agreement expressly permitting a greater amount than that which the client could have recovered from another party to the proceedings. So again, this goes back to a retainer point. If what you're being instructed to do is going to be a litigated county court matter, it's all about giving the client as much information as possible. Did they have basically, have they given informed consent? So it is worth being very clear and expressly permitting in your retainer with them that this point could arise. If you've covered that, then you're fine. But a general, well, you're not ever going to recover all of your costs on assessment isn't going to cut it. In other words, is be precise. I'm probably bored stiff with me talking about retainers, so I'm going to go back to basics now. Every cost specialist you talk to is going to talk about time recording, and we know how onerous it is. We have to time record as well, but I thought that this little example might actually illustrate the point, particularly when talking about your firms. Grade D fee earner working on 4 matters during a day, and that's probably the case, could well be more. And if they fail to record just 12 minutes of time on each of those matters and a guideline hourly rate, then your firm will have lost a little over £20,000 from that one fee earner over the year. The corresponding figure for a grade A, and these are using GHRs, obviously if you're using more than GHRs, the figures increase, is 41,000. So consider the number of grade A and D, and obviously all points in between. I cannot stress enough how important it is to record your time. Again, it's worth actually tasking a grade D fee earner or even a reliable non-fee earner to actually check this from time to time. If you don't have an internal cost team who you could ask to do it for you. Sorry, my finger's going trigger. Right, it is next. It's the nature of the work done. This is a possible way to increase your income. It's the nature of the work done which determines its recoverability into parties. An often quoted case, Brush and Cotbar, which defendants love throwing at you, I throw straight back at them because that was the case that set this principle. It's still good law. So a non-fee earner may do some work on a matter, but because they're a non-fee earner, they don't have a code to use your case management system to record their time. So just say a non-fee earner, clerk, secretary, whatever, takes a phone call from a client, and the client is giving fairly detailed instructions in response to something that you might have written to them. You're not out, you're in a meeting, you're on annual leave, whatever it happens to be. So that non-fee earner takes a note of those instructions and then sends it to the fee earner. That work, the work that non-fee earner did, is recoverable as if that call had been taken by a fee earner. At the moment, there is no way for them, in most firms, there is no way for that work to be picked up. But grade D fee earning work at guideline hourly rates, £126 an hour. Oh, sorry, minimum £126 an hour. 129 for London 3, I think, and goes up. So perhaps have a code or something within your CMS that allows such work to be recorded. At one point, and I think this may have been Jackson 2 set of recommendations, they were talking about creating a fifth grade, a grade E. That was rejected, but that is precisely where this type of work has been put down. But as I say, it's the nature of the work. Again, this sometimes applies, and this I've done a lot of group action work in my years of practice. Now, quite often in those where you have sort of vast teams and you're talking of literally millions, I did a budget in one case where the two sides budgets between them added up to £100 million, or fractionally over. You have teams, and sometimes even your grade D fee earners are effectively doing work that a grade C fee earner would do normally within a firm, because your grade Cs are working up and all the rest of it. Now, this is the type of thing that would hopefully be picked up by your cost people when they're costing a file, but it is possible that in certain cases, a grade D fee earner, this could just be used on assessment and increase the rates. But what I've done in the past and done successfully was to create a D plus grade within the firm's system. And then that just went in as a rate within the bell. Anyway, this was talking about non-fee earning work, or non-fee earners doing fee earning work. And moving on from that, you come to a point that I've been talking about for a long time. some of you may have heard of the case of Crane v. Cannon's Leisure, 2007 case, 15, 16 years ago. That affects people like us. So that established that when drafting bills of cost, we are effectively agents and counted as fee earners. So our work can be recovered as fee earning work, which is why we're always in the bill as grade D, or if you're a cost lawyer, C, or once I was able to obtain a B grade. It is unusual to get a B grade for drafting a bill, but it's quite possible to get a B grade for negotiating and for advocacy on cost hearings, be they budgeting or applications for interim costs or whatever it happens to be. A case of mine, my only reported case, yay, is one of Ahmed v. Aventis Pharma, which wasn't long after Crane. This established that where the solicitors outsourced the job of sorting and summarising the medical records, they could treat this work as forming part of their profit cost rather than being treated as a disbursement. The time spent copying and paginating wasn't recoverable. That's never fee earning work. So if you send this out to somebody to sort your medical records, and an awful lot of people do, always get them to separately record their time spent actually sorting through the records, putting them into order, and creating a summary of what those records say of the relevant points, because you will then be able to put that, you might pay them as a disbursement, but you're going to be able to put that time in the bill as grade D fee earning work. In Ahmed v. Aventis, I actually got 25% enhancement on that work because of the nature of the case. It was part of a group action. So it then goes on to the general point that any outsourced fee earning work, any outsourced work that can be counted as fee earning, i.e. work that, for example, in a large firm like Owen Mitchell, and there are others, Hugh James, I can just off the top of my head, actually have teams of nurses and other medical professionals working within the firm who actually do that. Do this work, doesn't need to be sent out, they're big enough to have their own people. That is always claimed and recovered as grade D fee earning work. So why, well, you can, even where you send it to an outside agent, and it is actually valuable. Right, the use of words is important. So for example, as you just saw on the last slide, copying and paginating isn't fee earning work, it's not recoverable. So I've just put here, as I say, you'll get these slides. Work described using the following words is rarely, if ever, recoverable inter partes. It's probably pretty much covered in your standard private client retainer, but can't be recovered, don't forget, or arguably can't be unless you pointed it out if it's a county court litigated case. But copying, paginating, researching, you can't recover inter partes looking at what a particular civil procedure rule says. You're expected to know that. It's expected to be subsumed within your hourly rate. And ditto, you're expected to know case law relating to the type of case that you're conducting or you're involved in. You can get it if it's a new case. So, for example, had it been us and Belsner and Karatich had just come out, that was new law that established new principles, then you can claim it. So, supervising. Supervising, again, is solicitor and client work effectively. It's not recoverable inter partes in the same way that looking into funding and advising on funding is not recoverable. Typing, dictating, and reading in. Reading in, basically, if there is another way to describe what work it is you're doing without being misleading, then use it. So quite often there will be changes of fee earner, in a very long case, you can justify that if you've got a very long running clin-neg case, it's not quite such an issue. But if you've got a change of conducting fee earner 3 or 4 times during a case that only runs for 3 or 4 years, then it's a major problem. You're not going to get the reading in time. However, if that happens to coincide with a particular stage of the matter that you're dealing with, that would justify reviewing the pleadings, etc., then in order to update the client, then describe it in that way, because that work is usually recoverable. So work that is usually recoverable, noting, but if you have a whole load of documents items that read preparing note of telephone call, etc., then that's not going to cut it. You'll get time for noting a substantial telephone call or telephone attendance, effectively, that you can refer back, but not noting a routine telephone call. So don't use it excessively. Creating a bundle index and checking the bundle is absolutely fine. Constantly getting paying parties saying preparation of bundles isn't fee earning work. Well, no, the paginating and copying part of it isn't, but actually creating the bundle index, supervising it, checking that it's correct, absolutely is fee earning work. And at the final checking stage is probably the A or B grade fee earner work, because a court will, you can lose a case on a badly prepared bundle because the judge is so hacked off trying to find things. Reviewing, fine. If you're, as I mentioned before, if you're reviewing in order to do something, just a periodic file review isn't going to cut it. But if you're reviewing the file to ensure that you've complied with court directions and that you've received everything that you need to receive from the other side, for example, that's fine. Drafting, preparing, attending, obviously it's fine. Discussing, this will usually refer to discussing with colleagues or inter-fee-earner discussions or team meetings are probably one of the most hotly contested or argued arguments between receiving and paying parties. There's case law to justify team meetings and inter-fee-earner liaison in large cases, certainly in group litigation, less so in a routine case, because they'll say, A, it's unnecessary, B, it's cost building, and C, it's supervision. Those are the arguments that are going to get thrown. So by all means, at certain stages, you're going to need to discuss the case with the other members of the team, or they're going to need to discuss it with you. But if that comes up time and time again, then it does lead to the assumption that it's padding, it's unnecessary work, and it's work that a paying party should not be saddled with, basically. Considering, definitely, it's to a certain extent it's the same as reviewing. You obviously have to read and consider pleadings that come in, counsel's advices that come in, medical reports that come in. So as I say, that's usually recoverable. A lot of the points that I've talked about so far contain, there's a couple of articles we're going to send you, as well as the slides from this. One is top tips to fee earners for maximising profit costs. So some of the points I've picked out are in there, along with some other ones. There's another one that's also going to get sent to you, which is called Cash Flow is King, which goes into what I'm going to say now, but in considerably more detail. Cash flow is obviously critical. I mean, really critical to the lifeblood of a firm. It is to elite law solicitors. It was to the original HM law cost draftsman before it became part of elite law solicitors. It's to everybody. And again, sorry, I have to keep referring back because my little box in the corner obscures part of my text. It's particularly important where a large part of your fee income comes from litigation, and even more so where a large percentage of clients are on CFAs. You don't always have to wait for the conclusion of a case to get paid. In clean cases, you can ask for a forthwith costs order on liability. Now, sometimes a court will order the liability costs to be paid. We had one really strange one recently where the court, instead of ordering that the liability costs be paid, ordered that all costs up to that point be paid. Equally, I've had another case where, because the court didn't put in the order for the word forthwith, and in fact that dispute is still ongoing, hasn't got to hearing yet. They've said that we weren't entitled to claim those costs because there was no forthwith order. It's part of a much bigger case and still hasn't come before the court. It's still a point dispute for them to adjudicate on. But it's safer to always try and put in the word forthwith when you get that. Always ask for a payment on account of your costs at the end of a case. It is surprising, I find it surprising that we still get bills to cost where there has been no provision for a payment on account of fees. There's a Tomlin order or whatever, but there is nothing in there about the paying party having to pay a sum of £20,000, £50,000 or whatever. And therefore you end up relying on, and we can do this obviously, your cost people, when they get the file, trying to get you a very quick payment on account. But there could be quite a gap in between the date of your order and us being able to get you a payment on account. It is always better to get it then, particularly as it's provided for under CPR 44.28, where the court orders a party to pay costs subject to detailed assessment. It will order that party to pay a reasonable sum on account of costs, unless there's good reason not to do so. So in other words, it's there, take advantage of it. The situation then arose where you've got a deemed cost order in respect of particularly Part 36. So the court clarified that this rule, the 44.28, applies in cases where a deemed cost order has been made on acceptance of a Part 36 offer. Therefore, when you conclude settlement with a paying party, again, always make provision for a payment on account to be made at that point. It will assist your cash flow enormously. Hopefully it will assist your cash flow enormously. The article goes into a lot more detail about that. Interestingly, going back to during the case, the large post office, Bates v. Post Office case, there were a series of trials listed to try different issues. And the claimants won a resounding victory on the, I think it was called the issues case. Yeah. And we got a cost order at that point for those costs. Now, considering that at that point, they were fighting absolutely everything, even trying to get the judge to recuse himself and then taking that to Court of Appeal. It could have been some considerable time before the case settled and they needed the money. The judge thankfully agreed. Yes. This is, I think I might have missed a slide. Oops, I think I might have missed a slide. Sorry, I'm going back through everything, make sure I'm covering, because I thought I might have missed a slide. Now I can't, on my roller, get through. Apologies for this, everybody. Yes, fee earners. A frequent objection of paying parties is that a lower grade of fee earner should have done the work. Slides got out of order. As shown earlier, it's the nature of the work done that determines recoverability. But the nature of the work also determines the grade of fee earner that carries it out. Too often, as I've said, work that is probably capable of being carried out by a junior solicitor is carried out by conducting grade A or B fee earner, whose work is then limited to the grade C rate. This potentially loses you quite a lot of money per hour, as well as having wasted your time. Of course, if you can outsource that work to a fee earning agent charging, say, £60 an hour, then that grade C work makes you a profit of £118 per hour. The point that I made when I used to do these things face to face, a lot of firms have people who retire from full-time practice, but whose experience and expertise, they just want a quieter life, they want quality of life. There is nothing to stop you outsourcing work to them, literally, that you know that they can handle. £60 an hour on a freelance basis, working from home, say doing 3 hours a day, earning yourself a couple of £100 a day, 3 days a week. Yeah, that's good money for somebody who is wanting a quieter life. The only thing is that you need to cover your insurance, but that is covered, and how that is covered is in the larger document that you're going to get sent. Finally, a shameless plug: don't use your cost people just to draft bills and budgets and negotiate them. Firms with in-house cost teams have always known this. They use their cost team to do everything from advising on retainers, CFAs and client care letters, making sure those are correct, up to date, making sure that they've inserted things that come up from recent case law, like what I was just discussing earlier. In large firms, they sometimes make them part of their pitch team. They very rarely say anything, but they sit there in the background and feed in information to help a team assess whether work at a particular level or a particular rate is actually going to be profitable for a firm. Also checking the firm and the fee earner's profitability. So just occasionally doing spot checks on a file and saying, well, actually, you're putting all this time into it, but a lot of this is not going to be recoverable. So you may want to downgrade the level of fee earner who's doing the work. You may want to rein back on the amount of work that you're doing on a case. Obviously, the decision is then yours as the fee earner to take. And obviously advising on solicitor and client disputes. In-house teams do this. Your external providers, whether it's us or anybody else, can do all this. Just ask them. I can come in, do it on an ad hoc basis or on a regular basis. When I say generally cost neutral, within litigation, we're generally cost neutral. But just generally, this work, even if it's just improving a firm's practices, helping productivity and profitability, it's always going to be cost effective. I have absolutely no idea what the time is because my clock isn't up in the corner of the screen, so I don't know whether I've gone over, under, or anything else. Around about 45 minutes, I believe, so apologies for talking on so long. If anybody has any queries, as I say, I'll be sending out slides, making sure that they're all in the correct order, and the 2 articles which amplify some of the points that I've been raising. But if anybody has any questions and want to put their hands up, put anything in chat, please do. Otherwise, Helen, I think it's probably over to you if nobody has any questions.
I see. I think one's just
Got
popped
one
up.
raised hand, yeah.
You've got one just come up. Which insurance document did you mean?
Sorry.
A question's just come up.
Oh, sorry. Yes.
Sorry.
It's ensuring that if you did use somebody, as I was talking about, that basically your insurance would be the one that has to pay out. I will try and find the exact quote. I thought, to be honest, I'd actually put it in one of the slides, but as I say, my slides have somehow come up slightly out of order. But this is, if you do outsource, the case, in fact, it was my Ahmed v. Aventis Pharma case that actually said it. The senior cost judge, Andrew Goldsaker, when he was not the senior cost judge, he was actually a more junior one at the time. The characteristics of such work, this is in deciding whether the work was fee-earning work, is whether the solicitor remains responsible to the client for its proper conduct. Later said, I'm satisfied that the work done was solicitor's work. Had a mistake been made in that work, I have no doubt that the solicitors would have been responsible for it. Arguably, it's not necessary, I don't think, I remain to be contradicted on this point, that anybody who does that work actually has to be a qualified solicitor, i.e. somebody who wants to retire, does not want to renew their practicing certificate, in other words, is a solicitor without a practicing certificate, but is effectively a consultant to the firm, is effectively the same as I am. I'm a consultant, effectively. My work is recoverable, sorry, not my work, because I don't draft bills anymore, but somebody who is a cost expert who's drafted a bill, their work, Cranby Cannons Leisure, is recoverable as parties. So an external cost consultant is. And it becomes, as he says, who's responsible for the work. At the end of the day, it's the solicitor who's commissioned that work. So purely, it's just a question potentially of checking whether the insurance that covers your firm covers consultants. Now, for example, cost lawyers, we are required to have our own professional indemnity insurance in place. Somewhere, if there is a mistake and there is a cock-up and somebody ends up suing because of that, sorry, if there is an error somewhere, I shouldn't use the phrase I just used, then who is responsible? Because insurers will always try and palm it off. So the only point I was making was that is the advice that I was giving as a way to maximize your profit on work that is done, might be to use external cost consultants, including non-practicing solicitors, but check your insurance position and make sure that you're covered or that they are covered. That was the only point I wanted to make.
Thanks, Sue. We've got a couple more questions that have come in as well. So Julie's asked, is there a different regime for challenging costs for non-contentious work to contentious work? Your talk is focused on litigation.
It is indeed. And to be honest, I'm not the right person to answer that question. If you want to, we do have a non-contentious person expert in-house, so, and it's not me. So please, can you forward that query to me, Helen?
Yep, no problem.
I'll make sure that somebody in the firm answers that.
No problem. And last question that I can see for now, how reliable can we regard our time recording if the rules you have referred to about what is and is not recoverable that non-contentious souls are not familiar with may be applied retrospectively when, if costs are challenged? Yeah,
we quite often get exported time recording systems now when we're costing files. We used to get big paper files and it was much easier. I would say on a percentage basis, probably at least a quarter of entries are misdescribed. The major area is describing to the wrong phase, because that's very difficult for anybody to do. But there is a lot of work that it comes. That's where you rely in the end on people like us, because whoever it is who's costing your files, they can't just export. The judiciary seem to think that, or some of the judiciary, sorry, not cost judging, seem to think that the art of preparing a bill of course is just importing the time recording system and it's all dead easy. No, it isn't, because a lot of the work of costing a bill is actually going through your systems and actually rewording and redescribing the work that you've done where it needs it. And I would say 25% on average is probably about right. Sometimes more accurate than others. But yeah, probably about a quarter of things aren't. If you're preparing your own claims based on your time recording system, that is something to watch out for. If you're not, then this is something that can be and should be picked up by cost firms. Yes, should you be recording your work in a different way using different words? Yes, very much so. But that's where, as I say, it might help if you were to get some advice on that from whoever you use for your cost work, because any sort of certainly regulated cost law and to be honest, a considerable number of experienced cost draftsmen who aren't qualified cost lawyers would be perfectly capable of doing that work.
I think that's it. So unless anyone has any last questions, ask now or forever hold your peace.
I mean, if it's all right by you, Helen, because you'll be sending out this the info, and if you're happy to have the occasional question arising, if anybody thinks of anything, particularly once you've seen the slides again and seen the 2 articles, I'm quite happy to receive queries, via Helen, or if she prefers, I'll stick my email on that and you can contact me direct.
Thank you. Thanks so much, Sue. Yes, we will send the recording along with the slides and the articles to everybody, hopefully today. If not, it will be tomorrow. Yes, feel free to send any questions on. So thanks so much, Sue, for everything. And thank you, everyone, for joining us. Have a lovely day. Enjoy the sunshine. And we'll hopefully see you soon.
Bye.
Thank you.